I want to get a little bit more into that, right? Because obviously, I think the average gun owner would say, "Well, Bruen, they said public gun carry is a constitutionally protected right under the Second Amendment. So isn't that clearly established, right?" But as you write in your piece, the issue with that is they're not necessarily going straight at what Bruen specifically dealt with, right? They're doing something else. You call it loopholing. Can you explain this a little bit?
Yeah, so the loopholing idea is that what they're trying to do is find some legal artifice by which they can ban public carry. Now, they can't come out and say it is unlawful to carry a firearm in public. That would be squarely opposed to what Bruen held, and a court would enjoin that in 2 seconds. But what they're trying to do is say, okay, well, Bruen said you can generally carry a gun, but it didn't say you could have a gun in a school. And I think most people on both sides agree that there's no constitutional right to have a gun in a school. Well, we're going to say a school, and then we're going to say a hospital. And, you have a federal law, the Federal Gun-Free School Zones Act, that says not only the school, but 1,000 feet from the school. And what they're trying to do is basically add up all these. They're trying to do two things. One, they're trying to add up all these sensitive places to basically replicate a general ban. And so what they're in essence doing is trying to find, if they can't ban it directly, they're trying to find a legal loophole that lets them do it indirectly. The second thing that they're trying to do is they're often, some of these bans extend to parking lots and to other things. And what they're trying to leverage are what is known academically as the spillover effects. That, if you can't carry a gun in the school and you can't have the gun in your car, then you also can't have the gun when you go to and from the school. And for, many regular people, maybe you go to work, you come home from work, you pick your children up at school, you run an errand, and then you come home. Well, if you can't have the gun in the school or anywhere near the school, then you also can't have the gun while you're working. You can't have the gun when you're running your errand. You would have to go home first. And so, their hope is that if they have enough locations that are off limits, and there's nowhere to store the guns, it'll be too impractical to carry a gun and people won't do it.
Yeah. I think that's why I've called these effective bans, because they're not technically, you could carry some places, but even in less restrictive areas like Washington, D.C., for example, public carry on public transit is banned, which makes it much more difficult if you don't have a car to get around to ever carry a gun, right? I mean, that's sort of the point you're getting at here.
Yes, that's exactly. I think that's exactly the purpose. And I think public transit bans kind of come in two forms. In a lot of jurisdictions, it may not matter that much because people aren't particularly reliant on public transit. And, I don't know, a ban on public transit in the city of Los Angeles, maybe it doesn't matter that much because so few people take it. They all have their own cars. But there are a lot of urban areas like New York and DC where driving a car is actively discouraged. And a ban on public transit is a lot more significant because it's not just the ban on public transit. It's also the ban on anywhere you go after being on public transit. And so in essence, in an area that's actively discouraging people from driving their cars or owning a car, a ban on public transit may be basically limiting individuals to walking distance.
Yeah, it's also pretty regressive based on the fact that a lot of poorer people are the ones who rely on public transit exclusively because they can't. It's very expensive often to keep a car in some of these cities, but yes. It's a bit ancillary to what we're getting at, but it's an important point, I think.
It's not totally ancillary because a lot of these laws do have this regressive effect of banning gun carry effectively by poorer citizens. So if they can't afford their own car, there's no way for them to comply with the Gun-Free School Zones Act. In some places, they might not have a private driveway. Maybe they do have to carry a gun from an apartment to a public street to access, if they do have a car, to access their car. And, in some jurisdictions, there's no lawful way to do that.
Right. Yeah, fair point. But so, another thing that I think you get at that is a valuable insight involves the fact that, some of these loopholes that they're going for are just only a hair away from what the Supreme Court was explicitly saying you can't do. For instance, in New York, in Bruen, the Supreme Court, the majority talks about how you can't just make Manhattan, the whole island, off limits because it's crowded and has a police department, right? That was sort of one of the counter arguments in the case. And so New York, instead of making all of Manhattan off limits, made large sections of some neighborhoods off limits. For instance, Times Square, that just made a vague area that they classify as Times Square, well past the famous areas, and said you can't carry here. And that's really not that far off. And you could say that for a lot of these sensitive places in these other jurisdictions. But and a lot of the district court level, you've seen judges say no to this. But for instance, the Second Circuit Court of Appeals has said this is acceptable under Bruen. Why do you think that is?
So the Second Circuit said it was acceptable, but that was only on a preliminary review, and it was sent back for more factual development.
Sure.
I think one thing that gun owners who challenge these laws have to be careful to do is to develop fully what the impact of these restrictions are. I think it's one, it doesn't always occur to the judges when they hear hospitals and parks and 100 feet. They don't always fully internalize what the cumulative effect of all these things are. And I think in some of the more recent litigation, the lawyers are getting a little bit better about including maps and drawing out like what this effectively means. So the Second Circuit's ruling was still in a preliminary stage. Now, as you noted about Times Square, this came up at oral argument in Bruen, and what basically New York did is said, well, we're not going to only include Times Square, but the entire thing that they call the Times Square Business District, which includes a whole bunch of businesses that are blocks away. You can't even see Times Square from a lot of these places.
Yeah, go ahead. Sorry.
I was saying, the question on the loopholing front, the idea behind qualified immunity is that you do not want to impede officers from vigorously enforcing the law because of fear of personal liability. Now, it turns out there's some research by Joanna Schwartz and some other, officers almost never pay the judgments. The judgments are almost always paid either by the municipality or the insurance company. But that message has never trickled down to the courts. The courts are afraid that if they impose liability like they used to in the old days, that officers are just going to sit back and not want to enforce the law. The question I was asking, the piece that you mentioned, is, are we going to take a perversion of this doctrine, which, you can understand that if the law is unclear, you might not want the officer to face personal liability if he guesses wrong. But what you have here is kind of an abuse of that doctrine, where what they're trying to do is say, okay, you decided X, but we're going to try to replicate X with Y. So the goal that we have is the unconstitutional goal of generally banning public carry. And the question is that immunity going to extend just because the court has not ruled on the particular legal artifice to accomplish the unconstitutional ends? And I was suggesting that where you intend a patently unconstitutional objective, maybe it shouldn't matter that the court hasn't yet ruled on the specific means to attain those unconstitutional ends. The fact that you intend unconstitutional ends should be the end of the immunity analysis.
Yeah, essentially, because the argument goes that because these lawmakers are essentially laying out the fact that they are trying to infringe on this right the Supreme Court has identified, that is their intention going into it, that should play a role in whether or not those enforcing it receive qualified immunity, right?
Yeah, and it's not just the fact that they're subjectively motivated by this. Like, they are actually seeking an unconstitutional objective. And qualified immunity was never intended to shield those who deliberately act unconstitutionally. It was intended to, shield those, especially in areas where the law was rapidly changing, from facing liability if they guessed wrong on where the law would develop. And I think perfectly legitimate case of qualified immunity in this space. The legislature bans guns in schools, courthouses, and hospitals. And, maybe the officer knows that schools and courthouses are fine. He's genuinely unsure whether the ban on hospitals will be upheld or not. The courts don't want the officer to face, if he faces somebody with a gun in a hospital, a genuine dilemma about what to do because of uncertainty about what the courts are going to do with that. But the ban on guns in hospitals is a mile away from the ban on guns on basically all private property, which is a de facto ban on guns throughout the jurisdiction. Or, the even more extreme case in New Jersey is the ban on loaded carry in all private vehicles.
Right.
Which is, you can only carry in New Jersey under the statute if you're walking. I don't think there's any question that's unconstitutional.